Today, we are covering whether or not the TikTok ban is going to get a reprieve, or is TikTok out of operation? There are two cases technically on docket today. They've been consolidated. We're going to talk about what that means. We're going to talk about really the heart of this issue. If you've not watched Supreme Court arguments before, we will talk about the different standards you're going to hear about. We'll talk about what they're trying to decide today. But could TikTok cease operations in the United States as of January 19th? Yes, that is a real possibility. Congress of the United States passed an act that is and I'm reading this directly because otherwise I'm not going to get it right, the Protecting Americans from Foreign Adversary Controlled Applications Act. So that was passed by Congress. TikTok and a group of creators sued and said, yo, Congress, remember that whole you shall pass no law, First Amendment free speech. This is a speech platform. You can't ban it. What are you doing? Congress said, cute, but this is a foreign controlled app and they do not have a free speech right. So too bad. This wandered through the courts. The courts agreed with Congress and said, yes, this law is constitutional. What is the Supreme Court trying to decide? They are evaluating whether or not the law or the act passed by Congress is constitutional.
We will hear argument this morning in case 24-656, TikTok versus Garland, and the consolidated case. Mr. Francisco.
The consolidated case.
Mr. Chief Justice, and may it please the court.
This is Mr. Francisco.
Under the act,
for TikTok,
one of America's most popular speech platforms will shut down in 9 days. That shouldn't happen for 3 reasons. First, TikTok Incorporated is a U.S. company speaking in the United States. The act requires it to go dark unless ByteDance executes a qualified divestiture. Whether you call that a ban or a divestiture.
Divestiture meaning it has to sell. And TikTok has said they don't want to sell. So the divestiture is you have to sell or you're banned. They're not selling between now and the 19th. That's just not even practical.
One thing is clear. It's a burden on TikTok's speech. So the First Amendment applies. Second, the act is content-based from beginning to end. It applies only to social media platforms that have user-generated content, except for business, product, and travel reviews. Within that content-based universe, it singles out a single speaker for uniquely harsh treatment. And it does so because the government fears that China could, in the future, indirectly pressure TikTok to disseminate foreign misinformation and propaganda. Finally, the act can't satisfy any standard of scrutiny.
Oh.
The government has no valid
rational
interest
basis
in preventing foreign propaganda.
Okay.
And its fallback that it seeks merely to prevent covertness makes no sense, since that could be addressed with a risk disclosure. The government's real target, rather, is the speech itself. Its fear that Americans, even if fully informed, could be persuaded by Chinese misinformation. That, however, is a decision that the First Amendment leaves to the people. Given that the government's data security rationale cannot independently sustain the act, it is also grossly under-inclusive and ignores the most obvious, less restrictive alternative, simply banning TikTok Incorporated from sharing any sensitive user data with anyone. In short, this act should not stand. At a minimum, you should preliminarily enjoin it, which will allow you to carefully consider this momentous issue and, for the reasons explained by the president-elect, potentially moot the case.
A lot happened today in court, and I'm very interested to see not just what happens on the 19th, but what the fallout is from them seemingly throwing open the door to their own Section 230 protection. I'm very curious to see where we go from here. Very interesting to me is that the arguments from the platform seem to throw Section 230, which is part of the 1996 Communications Act that platforms rely on to operate. If Section 230 goes away, everything we do on the internet changes drastically. But platforms heavily rely on Section 230 to prevent them from being sued for what user-generated content says on their platform. TikTok leaned in and said, our algorithm is an editorial decision. It's the first time I've ever heard a social media company say that before the court. Most social media companies that come before the court, and there have been numerous in the last few years, come to the court and say, our algorithm is not an editor. Our algorithm does not make publication decisions. We are not a publisher as a platform. We are more like a host. We host the user-generated content. We do not editorialize. We do not act as a publisher. TikTok came into the Supreme Court today and said, our algorithm is the editor. That is the editorial genius that makes TikTok different. And getting rid of that genius and separating us from that algorithm, which is really the underlying heart here, not just somebody else needs to own the company, but then you also can't associate with that algorithm. That's really the core of the issue for TikTok, is we don't want to have to go get a different algorithm, and we don't want to operate with a different algorithm, is that our algorithm is making editorial decisions. And that to me is wild, that is the argument. I know you have lots of questions. We've got lots of questions, but where we go from here, I am going to keep following. I'm very interested on how other social media platforms respond to this. Will TikTok's argument that their algorithm is in fact an editor impact other platforms? We will have to see. Is it going to come up? Yes. In the cases I cover, you've seen it. We cover a case in Florida, the Laundry Petito civil suit. They started talking about the Depp Heard case in court from Virginia. We've seen things that happened in South Carolina in the Murdaugh case, referenced back in the Karen Reed case in Massachusetts. So does what TikTok argues here come up in other arguments? Yes. And have there been numerous lawsuits over whether or not you can sue YouTube, for example, in a case that I covered? Can you sue YouTube for the videos that they show, for the decisions that the algorithm makes, and for the outcome of that? And the court has denied those in the past. But now you have a different social media platform saying, no, actually, we do editorialize. Our algorithm is in fact a publisher editor. And does that stop TikTok from coming forward in court and saying, no, we have Section 230 protection? Did TikTok undermine its own Section 230 protection? And will we see others coming forward and suing TikTok? In the TikTok psychic lawsuit, do you see the professor in Idaho now coming forward and saying, oh, TikTok, you're saying that you're the editor? Fine. The TikTok psychic doesn't have any money, but you sure the fuck do. So we're going to now sue you too, because you went into court and argued that your algorithm is in fact an editor making editorial decisions. So let's sue you. So is this going to change the way other litigations move forward? Are we going to see other lawsuits against TikTok open up and saying, hey, TikTok, your lawyers went in and argued in front of the Supreme Court that your algorithm is an editor. So you are stopped from coming into court and making a contrary argument and saying that you're not. Did they just throw open the door on lawsuits for TikTok? And could that ultimately change TikTok? I don't know how YouTube operates if YouTube is open to suit for everything everyone ever publishes on the platform. I don't know how any user-generated form would operate in that environment. And in the lawsuits that I covered regarding Twitter and YouTube specifically arguing that they could not operate in that environment, did TikTok just create that environment for themselves, arguing that they are in fact a publisher and therefore not subject to 230 protection?
Mr. Chief Justice, and may it please the court, wholly apart from the company's...
Mr. Fisher is the attorney for the TikTok creators. There are two cases here that are consolidated. One is TikTok Inc., the US-based company of TikTok. The other is the TikTok creators, and there's a 5 or 6 creators that sued. So there are numerous creators that sued. Jeffrey Fisher is the attorney for the content creators, saying that their speech is being infringed upon by this law. And this law, as it applies to the content creators, is unconstitutional. So we're going to get similar but different arguments here because we're coming from the perspective of the content creators.
Legal interests here. The act directly restricts the rights, the First Amendment rights of American creators to participate and speak in what the court a little less than a decade ago called the modern public square. And what you might say today is the most vibrant speech forum in the United States of America. And the act, therefore, is inescapably subject to strict scrutiny because of the First Amendment implications. And the act fails that test, and indeed any level of scrutiny under this court's case law, because the act and the reasons behind it defy our history and tradition, as well as precedent. American creators have long and always enjoyed the right to speak in conjunction with foreign speakers or work with foreign publishers. Americans even have the right under the Lamont case to receive information from foreign speakers, indeed foreign governments. So that leaves the government with this implication and its use of the phrase national security in this context. But that just simply doesn't change the calculus. Throughout our history, we have faced ideological campaigns by foreign adversaries. Yet under the First Amendment, mere ideas do not constitute a national security threat. Restricting speech because it might sow doubt about our leaders or undermine democracy are kind of things our enemies do. It is not what we do in this country. And so we think the court should reverse, and I would welcome the court's questions.
The Solicitor General is going to argue on behalf of the government. Remember, we are watching Supreme Court arguments regarding the law that was passed by Congress that is being called the TikTok ban. The law requires that either TikTok divest its ownership and association with ByteDance, or they can no longer be hosted in the US App Store. They shouldn't be hosted on US servers, etc. TikTok has said this means either we have to sell or we have to go dark. That's the only option. The justices have pointed out other options. Couldn't you get a new algorithm? Couldn't you do this? Couldn't you do that? TikTok has said, essentially, we're not doing any of that. The only option here is divest or die. The justices are saying, you have other options, you just don't like them. So that's on you. We are now going to get to the government's arguments. We have heard from TikTok through their lawyers. We have heard from the creators that have sued through their lawyers. And now we are going to hear from the government that's going to respond to both, because the arguments, though slightly different, are similar. They are close enough.
Justice, and may it please the court.
So this is the
Chinese
Solicitor General.
government's control of TikTok poses a grave threat to national security. No one disputes that the PRC seeks to undermine U.S. interests by amassing vast quantities of sensitive data about Americans and by engaging in covert influence operations. And no one disputes that the PRC pursues those goals by compelling companies like ByteDance to secretly turn over data and carry out PRC directives. Those realities mean that the Chinese government could weaponize TikTok at any time to harm the United States. TikTok collects unprecedented amounts of personal data. And as Justice Sotomayor noted, it's not just about the 170 million American users.
Smart to directly pull out what the justices have said earlier in the arguments. Smart.
But also about their non-user contacts who might not even be engaging with the platform. That data would be incredibly valuable to the PRC. For years, the Chinese government has sought to build detailed profiles about Americans, where we live and work, who our friends and coworkers are, what our interests are, and what our vices are. TikTok's immense data set would give the PRC a powerful tool for harassment, recruitment, and espionage. On top of that, the Chinese government's control over TikTok gives it a potent weapon for covert influence operations. And my friends are wrong to suggest that Congress was seeking to suppress specific types of content or specific types of viewpoints. Instead, the national security harm arises from the very fact of a foreign adversary's capacity to secretly manipulate the platform to advance its geopolitical goals in whatever form that kind of covert operation might take. The act addresses the threat of foreign adversary control with laser-like focus. It requires only divestiture of TikTok to prevent Chinese government control. And that divestiture remedy follows a long tradition of barring foreign control of U.S. communications channels and other critical infrastructure. So no matter what level of First Amendment scrutiny applies, this act is valid because it's narrowly tailored to address compelling national security threats. Now, my friend Mr. Fisher just emphasized, and I acknowledge, that millions of Americans enjoy expressing themselves on this platform. But the important thing to recognize is that the act leaves all of that speech unrestricted once TikTok is freed from foreign adversary control. The First Amendment does not bar Congress from taking that critical and targeted step to protect our nation's security.
At the end of oral arguments with the Supreme Court, we heard from the consolidated cases, the lawyers from TikTok, the lawyer representing TikTok creators, and the Solicitor General from the government. The Supreme Court is being asked to do two things with regard to TikTok. One, either do an administrative stay or an injunction to pause this law from going into effect on January 19th, the day before the inauguration of the next administration, or to rule on it outright. But really, they are focused on, we would like you to stay it first. The court asked all of the attorneys, what happens if the law goes into effect? And the attorneys for both the creators and for TikTok indicated that essentially, if this goes into effect on the 19th, TikTok will go dark. That's not my understanding of how this law would actually play out. And the government has said part of the date of the 19th is a game of chicken here. TikTok keeps saying, yes, it will go dark. No, there's no way we can divest. No, we're not allowed to divest from the government of China. They have said no. TikTok US cannot divest from its ownership and from ByteDance and have the algorithm. That can't be exported, which means data from the US has to be exported to continue to inform and operate through the algorithm of TikTok. But my understanding is that the servers could be an issue because Oracle could choose not to host that information on their servers anymore as of the 19th, which would cause problems. Would it be a complete blackout? I don't know. And the App Store could no longer have TikTok on it. If you already have TikTok on a device, would you be able to open it up and go on TikTok? Yes. What would that experience be like? Unsure, because if Oracle stops hosting the servers, then you are going to have a big issue on the 19th, which may happen. It's a very real possibility. The court could also issue an injunction for a week or however long they would like to. So we'll see if the court issues an administrative stay or an injunction. The government is asking that the court let this law go into effect as it is and says that this law is constitutional. And that's the second part that the Supreme Court has to decide. Is this law constitutional as written? Part of the argument is over the level of scrutiny. What standard is the court going to apply to this law to determine if it is constitutional? The government argued this goes to intermediate scrutiny. The TikTok et al. Plaintiffs said, no, this needs strict scrutiny, and if so, it doesn't meet it. What level of scrutiny the court applies matters quite a bit. The government argued, look, no matter what level of scrutiny you apply, this law is constitutional. TikTok and the creators said, whatever standard of review you apply, this law is not constitutional. So two parts. Will there be a stay? And will this law be determined to be constitutional or unconstitutional? Is this an issue of national security? Is this a government restriction on speech? And how will the court parse the two? We will have to wait and see. The court can take quite a long time with their written decisions. I hope we will see some decision on whether or not they will allow for an injunction or not. Hopefully they will say either yes or no to that part before the 19th, but TikTok is in limbo. And my suggestion is, if there are creators you love to support on TikTok, those creators' livelihoods are potentially going to be upended. Find them on other platforms, at least in the meantime, while the uncertainty is happening. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.